Okay, this is Life in the Mix, yeah. And I just wanted to clip this little bit and share it because I feel that it's very important. Even though that I'm not living over in England, it's coming over to Ireland as well soon. But it's important for parents to know that they are the main educator for their children, not the schools. You as parents, you are the main educator to your children. So I feel this is very important to share, and I just want you to all share it around and just do as he says.
Why is the silent briefing? Of course, got to do with the digital ID that they're going to implement in the schools, they say. Oh, not good, not good. So, what I have moved to do this evening is put together a formal notice, a cover note for that notice, a response notice if they're not playing ball, and then a notice to your MP if you so wish. Now, as is usually the case, it's a document that's on the website and you guys will be able to pick it up under this video once we've completed. So without further ado, let's crack on. Now, more important than anything is that people understand when you're formulating these notices, you don't want to use the words person, child, children, parent, or indeed guardian. These are legal terms that act to the benefit of the state. So now we'll start it with what it would be a suggested cover letter to this notice. Of course, you can play with these as you wish. You can formulate them in a manner that you would write them. But basically, the structure that you would wish to get together in order for it to have some standing are as follows. So this can be sent as a cover notice to frame your intent respectfully. So the subject would be Mother and Father Notice regarding digital ID implementation. Dear, and the head teacher's name, we are writing to formally express our position regarding the proposed digital identification systems being introduced at, and then of course put the name of the school. As a natural mother and father of offspring's full name, so it would be your son or daughter's name, we do not consent to any biometric digital or data-driven identification measures being applied to our son, daughter, of course, whichever is applicable. We have enclosed a formal notice outlining our lawful position and the protections afforded to our family under UK and international law. We trust that the school will respect our decision and refrain from any action that would compromise our son or daughter's respectively privacy, autonomy or lawful standing. Thank you for your attention to this matter, sincerely, and then mother's name and father's name. So that's the cover letter. Now again, I'm prompting you with do not use the words person, child, children, parent or guardian. Okay, it's important that you get that if you're going to make it your own. So below is an initial notice you send to the school with, if you choose, the above cover letter accompanying it. So this is the initial notice titled Formal Notice of Non-Consent Regarding Digital Identification. To whom it may concern, well, of course, you would probably wish to put the head teacher and perhaps the governing body. We understand, we, the undersigned, hereby issue this formal notice to name of the school, its governing body, and any affiliated agents acting under the jurisdiction of the United Kingdom corporate governance structure. We assert our status as mother and father of offspring's name, born on and the date of birth, and do not consent to being referred to or bound by statute as parents under corporate or statutory definitions. Again, that's very important. The pair that rents, of course, you're renting them off the state in their system. So it's very important you don't use the word parent, okay? And you're making it clear there that you're not being bound by that title, even though they use it. Under corporate or statutory definitions, we act in our natural and lawful capacity, not as legal representatives or agents of any corporate entity. We have been made aware of proposals or requirements concerning the implementation of digital identification systems for minors enrolled at this institution. We do not consent to our offspring being enrolled, registered, or otherwise subjected to any digital ID scheme, biometric tracking, or data profiling under any public-private initiative, statutory instrument, or corporate policy. Furthermore, we deny any and all power of attorney, assumed or implied by the school, local authority, or any third party over our offspring. We do not grant authority to the school to act on behalf of our offspring in matters of identification, data collection, or technological enrolment. Any decision made by the school to proceed with digital ID implementation does not bind us nor our offspring in any legal, moral, or contractual capacity. And that's very important also, because if they do, at least you give them notice that they're doing that on their own bat, but it doesn't bind you or your offspring to any of the nonsense. This notice is issued in accordance with the following legal and human rights protections. Now, it's up to you whether you want to use the term human rights, because, of course, again, human is another term. However, presently, the courts do act and jump about when you put a human right statute in there. So that, again, is entirely up to you. So I'll do that again. This notice is issued in accordance with the following legal and human rights protections. The Universal Declaration of Human Rights, 1948, Article 6. Everyone has the right to recognition everywhere as a person before the law. And I've added in brackets, but we are not to be binded to take that title. So you're not bound by any law to actually claim to be a person. Again, that's rather important. The Human Rights Act 1998, Article 8, everyone has the right to respect for his private and family life, his home and his correspondence. Now, family, private and life are very important, and so is home, because you don't want to be a resident. A resident is a guest. You don't want to be the occupier, because, of course, that's a military term. Again, these are just words that you don't want to be mixing in there, because it can just complicate your standing. The Data Protection Act 2018 and UK GDPR, which require informed consent for the processing of personal data, especially that of minors. The Education Act 1996, Section 7, which affirms the duty of, in our case, mother and father to ensure their son, daughter, whichever respectively, receives suitable education, not the duty of the state to impose technological conditions. We reserve all rights, including the right to pursue lawful remedies should this notice be ignored or violated. Any attempt to override this notice will be considered a breach of trust and may be subject to legal action. Or lawful action would probably be a better term, but obviously most people understand things in legal. And again, sign that off, mother's full name, father's full name, and date it. Now we're going to go for a response. If they try to ignore it, etc., you would probably want a follow-on letter. So it's, again, do not use the words person, child, children, parent, or guardian. These are legal terms to the benefit of the state. Now, below is a strong, respectful follow-up response you can send if the school replies with resistance, legal jargon, or insists on proceeding with digital ID implementation despite your original notice. But, of course, you've covered yourself by claiming if they do, you are still giving them notice that neither you nor your offspring are going to be bound by the statutes that are attached to that scheme. So this is your follow-up response if necessary. Subject, reaffirmation of non-consent and lawful standing regarding digital identification. Dear, and then the head teacher's name. Thank you for your response to our previous notice regarding the proposed digital identification measures at the school's name. Now, dear head teacher, it may also be wise to seek out the governor of the governing body, because they're actually legally responsible as well. So it may be a good idea to address all these to the head teacher, and also find out who's the governor. Thank you for your response to our previous notice regarding the proposed digital identification measures at school. Remember, this is if they've responded. We wish to reaffirm our lawful position and clarify any misunderstanding that may have arisen. As stated in our original notice, we do not consent to our son or daughter, respectively, and then son or daughter's full name, being enrolled in any digital ID, biometric or data profiling system. Our position is not a matter of preference, it is a matter of lawful standing and under the authority held by the mother and father of said son and daughter's names. Now, so important to use mother and father, ladies and gentlemen. We remind you that our notice was issued in accordance with the Human Rights Act 1998, the Data Protection Act 2018 and UK GDPR, which require freely given, informed and specific consent, especially when processing the personal data of minors. Under the Education Act 1996, Section 7, it is our duty, not the state's, to ensure our son or daughter, respectively, receives suitable education. This duty does not include submission to technological schemes that compromise privacy or autonomy. We have not granted power of attorney to the school, local authority or any third party. Any attempt to act on our son or daughter's behalf in this matter is unauthorised and may constitute a breach of trust. We respectfully request that the school acknowledge our lawful notice and confirm in writing that our son or daughter will not be enrolled in any digital ID scheme, biometric system or related programme without our explicit consent. Should the school proceed in contradiction to our notice, we reserve the right to pursue lawful remedy, including formal complaint, data protection challenge and escalation to appropriate oversight bodies, and also directly to law. We make clear that any such action taken by the school in the implementation of the digital ID will not bind our son or daughter, or indeed mother and father, to statutes attached to the scheme. So you're making that clear again. We trust that the school's name will act in good faith and uphold the rights of families to make informed decisions regarding their offspring's privacy and identity. And again, sign that off: mother's name, father's name and date. Now, that's for the school. And this is if you choose to send it to your MP, because they are responsible for the temporal or the legal side of things. Again, I issue a caution: do not use the words person, child, children, parent or guardian. These are legal terms to the benefit of the state. Below is a tailored letter to your local MP or council authority that reinforces your lawful position and raises concern about digital ID implementation in schools. It's designed to be firm, respectful and politically aware, and that is below. Subject: urgent concern regarding digital ID implementation in schools. Dear MP's name or council officer, maybe send it to the chief executive of the council and the MP. I am writing to raise a matter of serious concern regarding the proposed implementation of digital identification systems for minors in UK schools, including biometric tracking and data profiling technologies. As the natural mother and father of the offspring's names, we have formally notified our son or daughter's school that we do not consent to any such measures being applied to our offspring. We reject the corporate redefinition of our role as parents and assert our lawful standing under common law and international human rights protections. Again, if you wish to use the human rights stuff. We are deeply troubled by the following: the lack of transparency surrounding digital ID rollout in schools, the absence of informed consent, especially regarding minors, the potential violation of privacy rights protected under the Human Rights Act 1998, Article 8, the risk of coercion where schools may act as agents of corporate or governmental schemes without, now I've missed that there, parental authority, without the authority of mother and father. You must change that. And if you're copying this and sending it on, cross that parental out and put mother and father. That's a mistake I've made. It's easy to make mistakes like that, ladies and gentlemen, but it's essential that you do not. So take note. You must understand these notices properly so that you know exactly what it is you've done. We remind you that under the Data Protection Act 2018 and UK GDPR, biometric and digital data collection requires freely given, specific and informed consent, especially for minors. Under the Education Act 1996, Section 7, it is our duty, not the state's, to ensure our son or daughter receives suitable education. that duty does not include submission to technological schemes that compromise privacy or autonomy. We respectfully request that you clarify your position on digital ID implementation in schools within your constituency. Confirm whether any public-private partnerships or pilot schemes are underway. Uphold the rights of families to opt out without penalty or discrimination. Ensure that schools are not acting beyond their lawful remit. In enforcing digital ID systems, we reserve all rights and will pursue lawful remedies should our offspring's privacy or autonomy be compromised. We look forward to your response and your commitment to protecting the rights of families in your constituency. And you sign that off, mother's name, father's name, maybe your address or your email, and also a date. You know, your address and email, you'd have to put your address, and perhaps you'd have to put your address on the cover note as well at the top. But that pretty much covers the cover letter, the initial notice, the follow-up notice, and if you shall choose a letter to your MP. So there, on the cover letter again, it's going to need your address, of course. I've missed that off as well, but I did put this together rather quickly just so that we can get that out before everybody starts to panic and believe that they have no standing to actually move against it. So that's basically what I wanted to put out today on this Wise Asylum briefing on this Monday, the 6th of October. And thanks for joining, you chaps.